Hi, everyone. I'm Kelly Ainsworth. I'm from TSEG. I'm joined here today with Matt Dolman, the founding attorney at Dolman Law Group. He is one of the leading experts, if not the expert, on the Roblox litigation.
Not the expert, but one of the leading experts, one of the leading firms in this litigation. Thanks for having me, Kelly.
Yeah, of course. Our goal today is to better understand the scope of the Roblox predatory behavior litigation, the issues at play, and why other attorneys might want to get involved.
Look forward to it.
So, Matt, for those of you who may not be as familiar, can you give us a brief overview of Roblox as a platform and why it's become such a focus of litigation?
Sure. So Roblox is the leading gaming platform for children, for adolescents. It's marketed as being safe for children 6 and above, and they estimate 80 million daily users. So we figure probably 40 million of those are bullshit bots. That's 40 million daily users. And this case relates to the systemic sexual predation of minors. It's the exploitation, grooming, and actual physical sexual abuse that's been facilitated by the Roblox gaming platform.
Yeah, that's terrible. So basically, Roblox maintains that these are isolated incidents, but plaintiffs argue that the
Mhm.
issues are systemic, like you were saying.
Yes.
From your experience in early discovery and handling arbitration, what patterns have you seen?
Sure. To be clear, we have not yet gone to an actual hearing regarding the arbitration issue. That's been tabled for right now. There's a petition that's actually pending that was filed last week by Anna Paul Weiss, and then we filed a petition in support of that petition with the JPML, and that's going to be heard on December 4th in Austin, Texas. Most likely, this case will be consolidated. So, but to go back to your question, we went back to your comment before that these are isolated events. And that's pretty much programmed by crisis management teams, by a public relations specialist on behalf of Roblox, and that's pure unadulterated bullshit. These are not isolated events. This is systemic abuse, and we know that from both anecdotal information from our clients and the amount of clients that are calling us on a daily basis, and let alone the law enforcement investigations, many of them resulting in arrests of sexual predators who cross state lines to meet up with children. But we also know that from the whistleblowers. And what Roblox doesn't know is how many whistleblowers we've already spoken to. When I say us, whether it's our firm, Anapol Weiss, who we're good friends with, um, Sonar Gould, that firm is very much involved in this case in the very beginning. We've all spoken to a number of whistleblowers, including Schlepp. Schlepp has received a lot of media attention. Schlepp's like a self-styled vigilante. And what he's providing to us, and what all these whistleblowers are providing to us, is notice discovery. That's what we're going to learn is when did Roblox know about this? And how often were they told? And while knew about this, they're speaking out of the other side of their mouth. They're cooperating with law enforcement on one side, but on the other side, they're telling the general public and their shareholders, they're touting the safety features of their product, saying this is a safe gaming environment for children 6 and above. So parents are left to believe, this is safe. You're sitting at a dinner table with your kids and you give your kid the tablet for a minute, just like a little peace of mind, a little quiet, and you don't know they're talking to an adult. Where else in this world can children speak to adults? And that goes on unabated every day on the Roblox gaming platform.
Yeah, and in the age of iPad kids, I'm sure
Mm-hmm.
this is happening way more often than we think.
Way more often, what we also see out there is a lot of parent shaming, a lot of victim
Mhm.
shaming.
Oh,
People are
yeah.
like, what are the parents doing? Well, I think I'm a responsible parent of 4 children, and there are many times where I've given my child a tablet for a few minutes, knowing that they're playing on Roblox. Okay, this is before I read the Bloomberg expose last February, thinking this is a very safe product. There's nothing to fear here. This is marketed as being safe for children 6 and above. I had no idea.
It's disturbing, honestly. So
Yes.
basically, what you were saying, one of Roblox's main defenses is
Mhm.
Section 230 immunity, meaning the law that shields platforms from liability for user-generated content.
Yep.
They're arguing that any harm comes from what the users create rather than them.
Mhm.
So, what I want to ask you is how are plaintiffs reframing this claim to instead focus on Roblox's own platform design and business practices?
So there's a growing body of case law that has come out over the last 2 years. And in fact, there was a recent decision in the Ninth Circuit Court of Appeals, and the order came out on August 1st, and it stands for the proposition that they're chipping away at 230, and at 230 is like a sword and shield for tech companies for content posted by third parties, but it stands for the proposition that we now have a roadmap for how to plead around 230. That 230 only relates to the content and the moderation of such content. It doesn't relate to the actual construct of the product itself. Roblox is a product, and it's a product that was never safe. It was never safe in its intended design. So this is a design defect case. It's been a design defect case from the very beginning. The more we discuss content or the moderation of such, we get into what's known as being a publisher. And when you get to a publisher argument, that's when you fall under the purview of Section 230. So it was a Twitter case that came out of the Ninth Circuit that basically gives us a roadmap for how to plead around 230, because 230 does not go into the actual construct of the design, the product itself.
Interesting.
Mm-hmm.
So, okay, so these cases that focus less on content moderation and more on the addictive and manipulative design of the game itself, those cases you're saying you do see traction in
I
treating
do.
Roblox as a product liability case?
Yeah, so the addiction cases are separate from ours, and there's some great lawyers involved in that. You have like AWKO and Kali Grombacher. That's the video game addiction litigation, and ours is much different. Ours relates to sexual predation of minors. So we're not actually making the argument about the addictive nature of the game. It's more of the game itself. This product was never safe in its intended design. They
Okay.
never created a safe space where children can just be with other children, other like-minded children, not speaking to adults that goes on unabated every day on the Roblox gaming platform that has become a haven for sexual predators who use it as a hunting ground to meet and prey on children.
See.
This
So
is
who
in one case
suffers?
is more disgusting than the next. I mean, it's repugnant, abhorrent behavior.
I see. So this litigation is focused on systemic failures and child
Mhm.
protection.
Yes,
How is that different from a lot of the typical mass torts we see in the industry?
sure. So, it's I guess it's different in two aspects. One, we're dealing with the most vulnerable of our population, children.
Mm-hmm.
Two, this is not a science-based, science-laden mass tort. So, when you look at a science-based pharmaceutical mass tort, you have to worry about federal preemption and Daubert. And the court has to act as a gatekeeper in a 702 hearing to determine the admissibility of certain experts who are going to proffer up scientific testimony. That's not, I mean, there's going to be testimony, there's going to be experts. They're going to speak to how unsafe the product is, and they're going to speak to the damages that these kids, these survivors, endured and what they're still going through. But it's not so science laden. So it's a much different type of mass tort. But again, we're protecting our most vulnerable population from a publicly traded company that has continually to misrepresent, they've materially misrepresented to the general public and their shareholders how safe this product is, knowing full well that these whistleblowers were telling them time and time again how dangerous this product is.
It's
They knew.
horrible.
It's terrible.
And so it's more mental and emotional than it is scientific.
Correct.
That makes
100%.
sense.
Mhm.
Now, looking at the case valuation side of things, can you
Mhm.
walk us through the tiered valuation of these cases? What does that
Sure.
mean from an advertising standpoint, intake standpoint?
No problem. So it's our firm, Anapol Weiss, and a couple other firms have gone together, and no one says they have to abide by this, but this is what we're basically doing, the
Right.
working group of
Use
lawyers who
specific
work on these cases.
tiers.
And this is how we're looking at grouping and classifying the cases as they come in. So we look at a tier one case as a case where the perpetrator met up with the child.
In
So
person, like face to
in
face.
person, generally physical sexual abuse, and it's the worst of the worst. And it's hard to put a value, and nor do I want to put a specific value on a case, because it's way too early. But those are cases that typically, if they're standalone and not part of an aggregate in terms of, you're trying to settle a mass group of cases, these are cases standalone value would be over $1.52 million all day, every day, even the most conservative of venues. So these are cases that one could, if you were looking at it, and I hate to, it sounds almost strange, a little bit cavalier to put a financial value and be discussing this regarding sexual abuse cases. But putting that aside for a second, hope no one judge me. Those are cases that we put a conservative value of at least $750,000 on. I'd be shocked if those cases settle for less than that. A tier two case is the child shared what's known as child sexual abuse materials. These are explicit photos of the children they shared with the adult perpetrator. Those cases, I mean, want to be very conservative. I would say that they have a value over $250,000, over 250. A tier three cases where the adult shared explicit images with the child after grooming. So I want to be clear, a tier two, tier three, this is after there was ongoing grooming and then which is a pattern of behavior where you're establishing a relationship with a minor child with a sexual intent. Um, the tier three cases we're putting conservative value of about $100,000 on. Probably worth more, but who knows? And again, it's very strange to discuss these values, especially so early. In a tier four case, that's just pure grooming. And we have to be very careful here. And I'm going to go into it, when as you go further into this discussion, that's where you're going to see the most fallout. And that's where you got to be very careful of what cases you're taking. And we will not take a tier four grooming case without having a documented behavioral incident or ongoing therapy where this was discussed with the therapist. You want like some kind of demarcation point where you're not relying on mom and dad giving you an anecdotal statement that Johnny is not the same as Johnny used to be. Johnny's withdrawn, he's angry, he's sullen. That's not going to fly. It's going to be very difficult to get that past judicial scrutiny, let alone defense. Um, we want to see behavioral issue. We want to see a documented therapy. And then tier five, and these aren't in sequential order because tier five is actually as bad as tier two and tier one cases. This is there was sexual grooming, and then it resulted in suicidal attempt, actual suicide. We have a few of those, and it's horrific, or self-mutilation by the child.
Wow.
Yeah, I mean these aren't for the faint of heart. These are some horrific cases.
Now, let me just ask you, do you ever find yourself getting emotionally invested in these cases?
I sure do. Hmm.
I can't
You're telling me
imagine.
I have four children. Um, yeah, these are not. It's tough, especially when you're dealing with the parents who blame themselves for what occurred when it's not their fault. They relied on misrepresentations, statements from a publicly traded company that their product was safe for children six and above.
It's heartbreaking,
It
honestly.
is.
Now,
Hmm.
let's talk timeline. Given the severity of these allegations, what kind of pressure, if any, do you think Roblox faces to resolve these cases?
When you ask about timeline, we can go through the pressures, but timeline's tough to say because it's so early and this is such a nascent litigation. It's brand new and discovery is only just beginning. And also some of it's stalled out right now while we wait for the JP Mill to have a ruling, and where the oral arguments will be in December 4th, the hearing.
December.
Um, I think this is going to be a much quicker timeline than your traditional mass tort one because it's not expert Latin, science Latin, but more specifically, they're going to face the same pressures. And we saw something similar in the Uber rideshare litigation, which I'm not a part of, but I have some good friends that were on the steering committee that are leading that litigation. And what we saw there is that the public pressure forced Uber to do away with the arbitration provision, arguing that arbitration was the form, which they're doing in this case. And we believe that that may cause Roblox to do the same thing here, but who knows? We don't control their behavior or conduct. They may still try to force arbitration down the throats of minor sexual abuse victims. Think about that. And we have many arguments of why arbitration should not apply. And I can get into that in a few minutes, but notwithstanding the fact that there's basically two threshold issues, arbitration and Section 230. I think once those are ferreted out, and they'll be ferreted out within the first year, there's not much else that Roblox can be able to defend these cases on. It just gets worse and worse for them the further we get into discovery. So do I think this will come to a swift resolution within a year and a half, 2 years? I do, but is there any guarantee of that? Absolutely not. Other mass torts, I hate to compare it to a science Latin mass tort, but you look at like talc. Talc's like the never-ending story. They're on year 10, 11, 12 of that case. So these cases sometimes drag on in perpetuity. I don't think we're going to see that with Roblox, though. I think there's going to be enough pressure on them, and their case is just so weak.
Yeah,
Outside of arbitration and trying to argue that this falls within 230 when we're arguing this is a design defect case, I think they're going to fail on both, and they're going to fail miserably on both.
I hope it wraps up
Yeah,
quickly. In
as do I.
litigations like this, marketing and execution could be seen as almost just as important as legal
Mhm.
strategy. And I
Pleasure.
assume, like you were saying, you're experiencing some pitfalls on the intake side of things. What
We
are
are.
some examples of those, and how do you plan on avoiding them?
In any type of mass litigation, we've handled a few of these in-house. You worry about the longer the project stays on, the more attrition you will have. How do you keep the clients engaged? And it's all about having as many touch points with these clients as possible, whether it's bi-weekly updates, town hall meetings that we've done in other mass tort projects. giving the clients video updates via both text message and email, and just trying to keep them as engaged as possible. And so far, we've been in this project for 6 months, and I would say this is a pretty engaged group. We're representing parents of sexual abuse survivors, and I would juxtapose that with like, we're involved in Latter-day Saints litigation, and there you're representing sexual abuse survivors that population could be very tough. In this case, you're dealing with the parents of minor children who tend to be more engaged. Um, Less often they go off the radar where we can't get a hold of them. So we're seeing very little fallout at this point. And I suspect as we go on, especially the strongest cases, I don't think they're going to fall out.
I see. That makes sense to me.
Mhm.
So, in cases and processes that are as lengthy and difficult as these, the
Mhm.
way you're keeping the clients engaged, you're saying you're sending updates in the litigation.
Yeah, whether hearing from myself or Stan, my business partner, or other partner, Sarah Beller, who just joined our firm from a well-known sexual abuse firm out in California. And we're updating the clients often, but more specifically, I mean, we're all trauma informed. We've been handling sexual abuse cases for a number of years now. This is a space that we're very comfortable in. And, you're seeing a lot of mass tort firms coming into the sexual abuse space, and it's not the same. Although this is going to be mass consolidated litigation, this is similar to a mass tort. In fact, I guess on a liberal definition, it is. But treating sexual abuse cases as mass tort claims, it's not the same. And these clients are much more difficult to deal with for good reason. And if you're not used to dealing with sexual abuse survivors, it can be troubling. And we've learned this from having dealt with this for several years now and improving our processes.
I'm sure they appreciate you and Stan personally reaching out and keeping them in the loop.
Mhm.
Now, to close things out, for firms who are considering involvement in the litigation, what do you see as the biggest opportunity? How can they play a role?
When you say biggest, I mean one of the biggest opportunities to partner up with a law firm that's incredibly competent, that's been involved since the very beginning, and the search engine guys, who I think is, if not one of the most, if not the most reputable lead generation company out there. That's an opportunity, but I don't want this to sound self-serving, like I'm just trying to plug us. So, what is the biggest opportunity to raise public awareness? To shame this company, Roblox, and Discord, by the way. I should mention that Discord is a defendant in a third of our lawsuits that have been filed so far. And that holds true for pretty much all the firms that are involved right now. As of this morning, there's 37 cases pending in federal court. I think 11, so a little under a third. My math's not the greatest, but a little under a third have Discord as a common defense. What often happens is, and I'm gonna land the plane, but Roblox is where the communication starts. Discord allows file-to-file sharing, so they'll go onto Discord, and that's where you see some of the most disgusting images that are shared. So they work in tandem. And Discord's like the Wild West, but I see the opportunity in shedding as much light on Roblox, on the fact that Roblox is trying to force these children to secretive proceedings known as arbitration, that they're trying to shame the whistleblowers, rather than actually shaming these sexual predators and shedding light on their own poor behavior by allowing this to become a hunting ground for children.
It's so shameful.
It is, but we feel like this is a very important project that hits home, and I think this is all for a very good cause.
Well, thank you so much for taking the time to sit down with me and explain a little bit more about this litigation.
Yeah, if you have any further questions, Stan and I will be at MTMP, and we'd be happy to talk to anyone about this case, what we've experienced so far, where we see the issues, where the strengths of this case, and why we think it's going to be a successful project.
Great, thank you.
Ellie, thank you for having me. I appreciate it.
Yeah. We'll be hosting a full webinar Q&A in the coming weeks. If you're interested, please reach out to RSVP.